Why don't you start, Archit?
At 5 p.m.
Hi, Abad. You're on.
Thank you, sir.
Thanks so much. Thanks so much.
Thank you, sir.
Why don't you start, Archit?
Yes, just 2 more minutes. We are just waiting for some more people to join in.
I think you should just give 5 minutes, Archit. Let people come because people are not able to log in easily. Thank you, sir.
Thanks so much. Thanks so much.
Thank you, sir. Archit, how many people have logged in?
60.
So give them 5-6 minutes. Yeah. You have a time slot till 7 only?
No.
So then wait.
Yes, just 2 more minutes. We are just waiting for some more people.
I think you should just give 5 minutes, Archit. Let people come because people are not able to log in easily.
So much.
Thank you, sir. Archit, how many people have logged in?
60.
So give them 5-6 minutes. You have a time slot till 7 only?
No.
So then wait.
Yes, just 2 more minutes. We are just waiting for some more people.
I think you should just give 5 minutes, Archit. Let people come because people are not able to log in easily.
Unbelievable, Abad, the way people are joining in. Fatafat.
How many have come so far?
67.
Unbelievable, Abad, the way people are joining in. Fatafat.
How many have come so far?
67. Jay. Jay. What user ID? I'm not getting user ID on what? User ID is one second, I'll just tell you. No, it's one. It's not I, it's one.
Hello. J is capital in the password, so people are not able to log in. J is capital.
Hi, Pankaj. Hi, Priyank.
Hi, sir.
Hello, Abhay. Hi, Abhay.
Good evening, sir.
Hi, Trisha.
Hello, sir.
Hi, Bharat. Hello, sir. Good evening.
Good evening.
Hello, sir. Hello, Archit, sir.
Yeah.
So I think we can start now. So, can you hear me, Mr. Ponda?
Unmute him.
Sir, can you hear me? I think we can start now.
Archit, can you hear me?
Yes, I can. Okay. So everyone, welcome to this webinar hosted by Jaikar and Partners, and we have the absolute delight and pleasure to have as our invitee today Senior Counsel Mr. Abad Ponda, an absolute encyclopedia on criminal law, who's agreed to give us this talk today. So we'd like to welcome you and thank you very much for giving us this time. We are delighted to have you, and without further ado, please, the floor is yours, the mic is yours, the screen is all yours. Thank you, sir.
Can you hear me, Archit? Can you hear me? Should I continue? Okay. Sorry about that. I hope I am audible. And the topic for today is a very hot topic today in the background of the fact that this is something which is actually happening in our society, but I'll come to that a little later. I first want to thank Mohan Bhai, Shamsher, Archit, and Jaikar Partners for this opportunity. It was indeed an honor to get another opportunity, and that too in the same week, to do some mental gymnastics with my mind, particularly in relation to the law, which I love. However, before I start about today's topic, I just want to point out in this grim corona atmosphere, we have a ray of hope. And for all those who are aware of what I'm going to say, pardon my ignorance, but I just learned something which is interesting. We are all persons who are jinxed by a 100-year jinx. In 1720, we were all hit by the plague. In 1820, it was cholera. In 1920, it was the Spanish flu. And now we've got the COVID problem. So this shall pass, and let's hope we get back to normalcy as soon as we can. Now, I'm going to give you an overview of what I propose to speak about today. But before I do that, I need to unequivocally and very clearly clarify that I only intend to share my personal views in this discussion and don't intend to directly or indirectly refer or relate to any publishing house or a news channel or any other broadcaster or persons connected or associated thereto. Any semblance or any resemblance with anybody to that effect is purely imaginary and coincidental. The next question, which is the subject matter of today's discussion, is one which is extremely important and relates to a situation where there's a conflict between two extremely important and valuable fundamental rights, namely the right of freedom of speech and expression of the press under Article 19 of the Constitution, and the right of the accused to have a fair inquiry and trial which is unbiased and saw any external influences, pressures, or prejudices by adverse media coverage. The latter right flows from Article 21 of the Constitution of India. Now, what is the right of the press? The right of the press is linked to a concept of crimes being public wrongs, and offences are one which offend and operate against the state. It is also relatable to the concept of courts being open to the public, and hence there exists both a right and the duty on the press to communicate their views on a hot burning topic to people at large who have the right to know about the same and about the same. As regards the rights of the accused under Article 21, they basically relate to the fact that every accused is presumed to be innocent until he is found guilty by a legally constituted court of law, which is the basis for its decision on well-defined rules both on substantive and procedural laws. Further, there is a presumption of innocence that the accused is required to be proved guilty beyond reasonable doubt and nothing short of that. Until then, he is considered innocent. Lastly, in our system of law, an accused has a right to silence, which is a fundamental right enshrined in Article 20, subclause 3 of the Constitution. Now, based on these three rights, the counter argument on behalf of the accused could be that if I am a person who's presumed to be innocent till the final verdict, then can I be painted sordidly as near guilty by the press or the media houses before my verdict on the basis of what the press believe is right or wrong? Secondly, if a person has a fundamental right to silence, is it not an affront to the said right and a bigger slap to fairness if he is slammed by the media and painted red and the prejudices go on rising in the minds of the common man only because of that one-sided publicity and only because he cannot controvert the allegations? The third argument in favor of the accused is, does media publicity not indirectly impact the views of judges, even if they're trained judicial minds, in inquiries like anticipatory bails or bails, and also in the final verdict in the trial? If all this is true, can it be said in actuality that a person is not being tried fairly and being deprived of a procedure which is not established by law, and his life and liberty is being curtailed by a procedure contrary to the view and contrary to the procedure established by law? So is there a violation basically of his fundamental right under Article 21? This is the debate. Now, in order to come to the forefront of this debate, I propose to discuss the following topics. Firstly, the importance of democracy and the press and Article 19 of our Constitution. Secondly, the concept of open courts in India. Thirdly, international covenants on the presumption of innocence and the right to silence and the position in India. Fourthly, some statutory provisions placing restrictions on the freedom of the press. Fifthly, Sahara versus SEBI case of 2012, where they dealt with sub judice cases where the matter was pending in the court and people were necessarily affected by publications made in the press. That matter would be entirely different and foreign to today's discussion, because what I propose to discuss today is pre-trial stage and pre-pending stage, namely at the investigation stage, what happens and what are the rights of the accused. Next, I propose to point out certain views of foreign nations about how the press tarnishes the image of individuals at the investigation stage and what is the impact. Then I want to point out how the Law Commission describes this in its 200th Law Commission report as the practical problem, and they point out practical difficulties. Then I would deal with the duties of the press and what is expected from them as per the judgments of our courts. Next, I'd point out whether contempt of court is actually the legal problem in this case, and the law of contempt is actually what is the problem. Then I would point out how, whether you can argue and say that a judicially trained mind like that of a judge can be said to be influenced by adverse media publications, or is it only juries in US and other countries who don't have trained minds that can be influenced? Can the citizen ask for a change in the law, or has he simply to accept this? And lastly, if he can, what is the solution? The importance of press in our democracy. Nobody can underestimate the importance of a press in disseminating information to the public at large. They have a right to freedom of speech, and a very valuable and a cherished right. And they provide great services in educating the public about what is going on worldwide, while we sit in the comforts of our houses. Speaking for the Constitutional Bench of the Supreme Court of 5 judges in 1958, in Express Newspapers Private Limited, their lordship said that there was no immunity of the press from the operation of general laws, but it would not be legitimate to subject the press to any kind of unnecessary restrictions to narrow down their rights to disseminate information to the public or curtail their freedom of speech and expression. No fetters were wanted that were not warranted in law. The court said that the Constitution must be interpreted in its fullest manner to see that the press get their rights guaranteed under Article 19 unless there are permissible restrictions. The Supreme Court further opined that complete freedom of speech and any means that resort to unnecessary restrictions were unnecessary and only legitimate restrictions under Article 19(2) of the Constitution were permissible. The first decision of the Supreme Court in this is Romesh Thapar's case. I don't propose to go into a history of Article 19. I only want to say that the importance of freedom of speech and expression was discussed in the 1950 SCR 90 for Romesh Thapar's case. A Madras resolution was passed by the authorities prohibiting the Crosswords magazine of India, Bombay, to be published in Madras and to be circulated. The grounds were that it violated public order. At that time, in Article 19 of the Constitution, public order was not finding a place in one of the 8 exceptions to Article 19(1) that gives the press its right to freedom of speech and expression. The Supreme Court therefore quashed that order, holding that even if public order was important, it was not sufficient to come to a conclusion that there was any abridgment of the rights of freedom of speech of the press. And as such, necessarily Romesh Thapar's case was upholding the right, and public order was not considered a valid restriction. Once after that, we have another judgment where the press and its role is identically and succinctly pointed out in 4 lines. Virendra versus State of Punjab 58 SCR, where it stated that it is a burning topic of the day. It is the duty of the press to publish it and point out the same to everybody so that ultimately persons are educated in the press to do their duty. Now, therefore, what stems from this is very clear that unless you fall within one of the restrictions to Article 19(2), and there are 8 restrictions, which I'll immediately read out and point out, a person cannot be restricted as a citizen to his right to freedom of speech and expression. This is clearly laid down in all these judgments and continues to be good law. Even today, we have the latest judgment of the Supreme Court on 66A of Justice Nariman in the Shreya Singhal case, where the same principle was laid down and the section was quashed on the ground that it didn't fall in the exceptions to Section 19. Now, Article 19 of the Constitution basically protects citizens and gives them a right to freedom of speech and expression. There is Article 19 subclause A, 1A. As I told you, Article 19 subclause 1A has 8 exceptions. And these exceptions are required to be carefully noted because today when we discuss these exceptions, we would have to fall in one of these exceptions to curtail the press. Article 19(2) basically says that nothing in clause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law so far as the law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India. That's the first exception. Certainly our case doesn't fall in that. The security of the state doesn't again fall there. Friendly relations with foreign states. Public order. Now, crimes are not public orders. They are private disputes, or rather they may be public causes, but they fall within the realm not of public order as per the judgments of the Supreme Court, where they discussed concentric circles in the Budlam Mohan Lohia case. Decency, morality. Now the important comes in the 6th in relation to contempt of court. So now the main question is, if the press pass negative, sordid and painted publications and they say things negatively against accused who are under investigation, can it fall within the definition and the foray of contempt of court? The next exception is defamation and the last is incitement to an offense. From our perspective, what is relevant for today's discussion is whether the case of the right of the press doing something which is affecting the rights of the accused under Article 21, falling in an exception to 19(2), namely contempt of court, so that persons can be curtailed from their right to free press and free speech. What is essential to note here is that in the 8 exceptions, what is included is contempt of court, but not the administration of justice. But Fortunately for us, in the definition of contempt of court, which we have under the Contempt of Courts Act 1971, administration of justice is part of contempt, criminal contempt. But there is another problem, namely that whether this administration of justice falls within the foray of contempt or not, I'll discuss a little later. The second important argument in favor of the press is that since courts are open, the public have a right to essentially know what's happening in courts, and public trials are not private. In Mohammad Shahabuddin versus State of Bihar 1510 SEC, page 653, the Apex Court pointed out how in civilized countries, the rule of law governed all of us, and criminal trials have to be public. The public and the press must have complete access. And public access is essential because ultimately it achieves the object of maintaining public confidence in the administration of justice. Publicity is the hallmark of judicial functioning, which is distinct from administrative functioning. Open trials serve as an important prophylactic, providing an outlet to the community concerned and giving them a chance to restore the balance when shocking crimes occur. People have an inherent distrust for secret trials, so democratic society demands that there is a public trial and the public know what is going on. What actually transpires is a public property, and open trial is the universal rule to be scrupulously followed unless there are exceptions. Section 327 of the Criminal Procedure Code again recognizes this right and basically says that trials in a criminal court shall necessarily in the first place be public trials. They shall be open to the public, and there are only one or two exceptions in section 327. The first is that the judge may, in a given case, looking at the exigencies of a particular case on an individual case-to-case basis, decide that the public at large or any individual should be excluded from a particular case in order to give effect to that case properly and to see that ultimately justice is done. And in a given case, if there is distraction or disruption, this can be resorted. The second exception under 327 is in rape cases of all kinds, starting from section 376A, 376 itself, A, B, C, D, and E, which are the new amended sections. The reason being obvious that in such cases, the identity of the victim should be maintained. It's not open to people to go and witness what she has to say because these are personal matters. And now the important part comes. Under section 327 subclause 3, the proceedings held under subclause 2 under camera shall not be published or printed in any court except with the permission of the court. Why I'm pointing out all this, it's going to be my submission at the end of all this, that you can curtail the powers of the press if your case falls under one of the exceptions to Article 19(2), or if there is a legislative provision like 327(3), which prohibits the press from publishing, and outright there is a bar on their right to publish, or there is some other kind of a judicial verdict in a given case, which I'll demonstrate sometime later about bans and postponement orders. There is no ban on the rights of the press. Under 327(3), the court can allow this if the victim consents or the IO consents, or there are certain contingencies. But this is one of the grounds on which the press can be curtailed. So the basic idea that I'm trying to demonstrate before everybody today is, in ordinary criminal matters, where there are no special provisions, where there are no legislative embargoes, where there is no hiatus to the press reporting, even if they trample upon the rights of an accused, can they say that they can't do so is going to be the main debate today. Now, coming back to some other provisions. Under section 33 of the Special Marriage Act 1954, the proceedings are to be in camera, and no printing or publishing shall take place, because if the printing or publishing takes place, you are liable to be punished except if there is permission by the High Court or the Supreme Court in this regard. Section 22 of the Hindu Marriage Act 1955 again points out to similar provisions and again says in camera proceedings not to print or publish, failure of which meets punishment under subclause 2. Section 14 of the Official Secrets Act is yet another provision where there is a bar to publishing, and the state proceedings with respect to secret proceedings, etc., are necessarily kept in camera, and no portion shall be published unless certain exceptions are made out, and public is also not allowed in the courts. The last provision I will highlight is 228A of the IPC, where it is prohibitory under certain cases to even publish the name of the victim, and like rape cases. And if they do so, it invites a punishment which is severe. Now, therefore, as I said earlier, and there's one more section, which I forgot, section 23 of the POCSO Act, which makes similar provisions prohibiting the media from publishing photographs or material in any manner of the witness or the identity of the child, unless there are exceptions which the court allows. Now, why I highlighted this again at the cost of repetition, where there's a statutory bar, there is no difficulty. There is a prohibition on the press to publish. The press dare not publish. They invite the wrath of the statute. But unless there is a statutory bar or there is a bar under 19.2, you fall in one of those 8 categories. The argument of the press is very potent and strong that we can necessarily publish and nobody can stop us. The damage that the press does in such publications, that's severe. I'll deal with them a little later, but just to tell you, if you hold a mini trial before the trial starts and you determine guilt based on your own notions, you hold a mini trial by carrying out your own investigation, by putting your own reporters on the job, and they collect their own evidence, and then you turn around and tell the police is clueless. They know nothing about the matter. Here's the evidence, I'll give it to you. Why are you not arresting them? Such people deserve to be caught. What's happening in this state? If this is going to take place, necessarily, you can't simply, according to me, and I'm going to now try to demonstrate this with some justification, that you can't simply bulldoze the rights of an accused even before the trial commences and expect right-minded persons to keep quiet about it. So now coming to the argument in favor of the accused, universally and internationally in various covenants and various declarations, the right to presumption of innocence and silence has been recognized. The Declaration of Human Rights 1948, Article 3 recognizes the right to life, liberty and security, while Article 10 provides for equality and a fair public hearing by an impartial tribunal. The impartial tribunal is very important. It's going to be my endeavor to point out to you based on some research and judgments that if you pollute the clear stream of reason of justice by such press coverages which necessarily have an impact on even a trained judicial mind, the stream of justice is never impartial and begins to get partial. Those images are going to remain in the minds of well-trained judges also, even if they're not jurors. And therefore, this will directly violate Article 10 of the Universal Rights, the Declaration of Human Rights, where you don't have an impartial tribunal and the determination of the charge is not solely on the basis of proof beyond doubt. Article 11, in consonance with the law in our country, is the presumption of innocence. Everybody charged shall be presumed to be innocent unless proved guilty by a public trial. Article 12 deals with the privacy and personal rights of a person and a family not to be attacked. It's also important because when you talk about a person being a criminal on a coverage or a TV or a newspaper or something, it affects the entire family, it affects its privacy. Photographs being flashed to an accused also affects a person's privacy, and how they will be dealt with by the European Union, I'll point out shortly. Nobody shall be arrested, exiled or detailed unnecessarily without there being material is Article 9. All this is being pointed out to show that when pressure is brought by persons who are not connected with the investigation to arrest people, it tantamounts to wrongful arrest, and sometimes fabrication of charges takes place to justify this arrest. Under the International Covenant of Civil and Political Rights 1966, which was ratified in India in 1976, everybody charged with a criminal offense under Article 14.2 shall be presumed to be innocent, and nobody shall be compelled to testify against himself, which is your right to silence. In 1994, there was a discussion in Madrid, in Spain. 40 distinguished jurists, legal experts, and media representatives convened at the International Commission of Jurists, and in a conference by UNICEF between 18th and 20th January, decided that they wanted to examine the relationship between the media and judicial independence as guaranteed in the UN principles of the independence of judiciary. And they wanted to formulate principles addressing the relationship between the freedom of expression and judicial independence. It was unanimously decided and resolved that some basic minimum standards would be there, and that the press, under Article 19 of that covenant, had no doubt an important function to disseminate information, and the media had to gather information and give it to the public. But it had to be done only not by violating the presumption of innocence, is what was decided. 6.2 of the European Convention of Human Rights protects the presumption of innocence, and German courts and the European courts have upheld this in many judgments, need not detail them. In India also, we share this presumption of innocence. Ranjit Singh, the famous ex-commissioner of police of Mumbai's case in 2005, is a classic illustration where this is upheld. And the earlier judgments of 2004-10, Narendra Singh, Rajesh Ranjan Yadav, and Bhatt versus Hegde are also worth noting, which are in 2007 and 8 respectively. Why I pointed out these covenants is in the line of the argument of the accused persons who are mostly illiterate, who don't know their rights, whose rights get minced and trampled even before the trial starts, or even before they are even charge sheeted. They have these rights in law, but they remain latent and dormant because of their inability to know it, or even if persons are educated and they know it. The problem is that if the damage is done, then it can't be undone. The Supreme Court of India in Sahara versus SEBI, which is 2012-10 SCC 603, had occasion to deal with a different kind of a situation where the press were interfering in proceedings. In that case, there was a pending case for the Supreme Court of India where, in the contempt jurisdiction, Sahara, who had opened out OFCDs, that's optionally fully convertible debentures, had to bring back the money into the public domain. The Supreme Court was seized of the matter, and during the pendency, the Supreme Court permitted an exchange of offers between Sahara and SEBI. The Supreme Court invited a consensus amongst them. So Sahara sent an email with an offer to SEBI. One of the news channels in Madras, in Chennai, picked this up and tried to point out that Sahara was offering some deficient amounts, insufficient security. The attempt to liquidate was not proper, it was collusive, and they broadcast something in the media. Senior counsel Fali Nariman, who was appearing for SEBI, took stern objection, and suo motu moved the Supreme Court by pointing out that this required to be dealt with. So 2 IAs, IA number 1 and 4, were moved by Sahara. What's interesting is that the prayers in that case in IA number 1 and 4 specifically related to pending proceedings, because there was a pending case in the Supreme Court of India. That was not a case where it was prior to the pendency in court, like an investigation of an accused or pre-charge sheet stage. There was another IA number 10 in which SEBI denied any collusion and said we would never leak something like this to the press, but we want you to lay down guidelines. And the SEBI supported this motion. I must, to dispel any doubts, tell everybody that there were a number of IAs moved in that matter. Many by accused persons who were trying to argue what I am stating today, or I am going to state today, that our rights are trampled because of what has happened at the investigation stage. The Supreme Court categorically said we are restricting our discussion to IA numbers 1, 4, and 10 only. And we are not going to decide the other IAs, and we keep that issue open. Therefore, the issue remained open and the issue was not discussed or decided. So therefore, today's discussion is an open discussion on virgin territory without there being any kind of a law laid down by our country as to what should be done and whether any remedies are possible in this case. Mind you, it's not that the Supreme Court has not dealt with an issue of press interfering in accused rights, trial or otherwise, or media by trial. The number of judgments. But what happens at the investigation stage and what are the remedies and what are the rights of the accused is something which remains in a territory that is not necessarily entrenched upon much. And therefore, I would try to do that today. However, in the Sahara and SEBI case, the Supreme Court culled out the notion of postponement orders. Again, after the damage is done in a trial, you say postpone publications in future. This doesn't help accused persons in the course of today's discussion, when the damage can be done earlier when you're at their stage of investigation. The Supreme Court spoke of postponement orders and said these postponement orders are necessary because they will necessarily be ones which can be passed in the rarest of rare cases only by Supreme Court or High Court, not by trial courts. In criminal courts, trial courts have no inherent jurisdiction. The Supreme Court said that these postponement orders can be passed for a limited duration because the test of Article 21 necessarily is one which must satisfy fairness and reasonableness, and Article 19 must cross this test by Article 21. And the Supreme Court basically said certain important things in para 42, namely, the postponement order should be for a limited duration without disturbing the content of the publication. And they should be passed only when there is substantial risk in trial proceedings or in court proceedings. If alternative methods like change of venue or other risk factors which affect the outcome of fairness can be resorted to, these orders should not be resorted to. These are only for a limited period where the offense or the act tantamounts to contempt of court because it affects court proceedings. Such restrictions would be reasonable restrictions within the meaning and the foray of Article 19(2) because it attracted contempt of court and in conformity with societal interests. It relied on Ministry of Affairs versus CCI, 95 SCC and Maneka Gandhi's case that unless the procedure of a particular act on the part of a person is fair, reasonable and proper, it would not pass the tests of 14, 19 and 21. It referred to directive principles of policy and certain cases where even with respect to violations of directive principles, because Article 21 is a fundamental right. But in the case of directive principles, one had to necessarily pass the test of 14, 19 and 21. So ultimately, the Supreme Court said, balancing of rights of the public and postponement orders in a given case where there is real and substantial prejudice to the proper administration of justice or a fair trial enumerates the necessities to satisfy one of the tests of 14 and 19(2). One cannot say that it is reasonable in the context of 14 or 21, it is not reasonable when it comes to 19(1)(a). Ultimately, postponement orders are only to balance conflicting interests of the public and interests under Article Part 3 of the Constitution. They must also satisfy proportionality within the meaning of Article 14 and 21. So this clearly was a case where they were dealing with a case of a pending case tantamounting to contempt. When there were proceedings in the Supreme Court and persons tried to publish something which necessarily was derogatory and criticizing an offer which was allowed to be made in the form of a no prejudice offer, the Supreme Court came very heavily down and said that this is not permissible and this is improper and we can pass postponement orders prohibiting that press house from doing this in the future or continuing with this article. And the Supreme Court censured to them would be a very serious matter because other newspapers would report this and say they did something wrong and they were censured. But this hardly solves the current problem. In relation to cases where at the investigation stage prior to charge sheet, importantly stages of bail, stages of anticipatory bail, where adverse press coverage is there, hardly solves the problem as to what is to be done at that stage. What is the solution? Does the citizen have any right, or is simply to fold his hands and watch what is happening? As I told you, it was only IA numbers 1, 4 and 10 that were decided and the Supreme Court said in our decision, we are confining it only to IA numbers 4, 5 and 10. This clarification is important because accused have filed several IAs which they sought relief on grounds that the trial is prejudiced on account of excessive media publicity. We express no opinion on the merits of those IAs. And again, if you want to know IA number 4, necessarily prayer clause B, prayer clause A and B in that was appropriate guidelines to be framed for reporting of the electronic and print media and matters which are sub judice in a court. Appropriate directions to be given for publicity of the print and electronic in court proceedings. So that doesn't solve our problem. I have to mention SEBI versus Sahara because necessarily it's an important matter. And let's now analyze what is our problem. Let's go into the problem. As I told you earlier, when a crime is committed, ordinarily, it is the duty of the police to investigate, and there is no reason why they should not investigate the case fairly and properly. If they're not investigating the case at all, there are remedies available in the law. You move the High Court in writ jurisdiction, or you move necessary proceedings under 156(3). There are legal provisions of the Criminal Procedure Code if the police is not doing their job properly. But for the press to say that the police are clueless, they have no idea what is happening, we are giving you the evidence, is completely wrong. This is the problem we face when they start interfering at the nascent stage of investigation. I have come across videos, and you can even try this for yourself on the internet, where before an accused is charge sheeted and after his arrest, while he is in police custody, the accused is made and paraded on the TV and made to say, "Maine aise mara, aise mara, aise mara." I am using it thrice because I've seen this video. Now, normally these confessions in police custody are hit by Section 25 of the Evidence Act. But imagine the impact of the trial judge if he sees this, and this man is put up by trial. Are you seriously suggesting he'll be able to sieve it out and strain it out of his mind? I very much doubt. And our courts have also said so, which I will deal with a little later. Then the whole gamut of this problem lies in the fact that media houses pressurize accused to be arrested. Why are they not arrested? And this is all pressure on the basis of their own notions. Police then fabricate evidence to justify the necessity to arrest the person because the media made noise or they would lose their jobs. Thereafter, the dangerous part starts. The victims' faces are morphed and they give bites. Their relatives give bites. They give gory details of the case, and the accused who's undefended in the TV or the newspaper necessarily is a person who can't speak. His photographs are put, his name is put. Parallel investigation by the media are most dangerous, can result in startling consequences. To give you an example, if the media record the statement of a witness and he gives a contrary statement at a later date to the police, that previous statement could be used in a court of law under Section 145 of the Evidence Act to contradict the witness. It affects the entire administration of justice and justice in itself. It could be a previous statement because our courts have taken a view, letters are previous statements, and any writing is a previous statement. The other thing is, if you show an accused person on the TV, if it's a case of an unknown accused, what is the value of an identification parade that takes place later on? Identification parades are parades which are required to be held when an unknown accused is involved in a case. And the law is very clear. If the accused is put up before the police by being shown to the suspects prior to that, or necessarily is a person whose photograph is seen, or if he's paraded prior to the parade loses its value and significance. That is the reason why the accused are necessarily produced ba parda, that is in parda. And they are produced in parda, I'm sorry, not ba parda. If they are produced ba parda, it's a ground for an acquittal. There are judgments. But if the photographs are flashed prior to the trial, it impacts the prosecution. It impacts the victim's case. It impacts the interest of justice. The other thing is that weapons are recovered generally by the police under Section 27 of the Evidence Act. The accused confession to a police is hit by 162 and 25, but necessarily if a recovery or a discovery of clothes or weapons comes, it is admissible and can be used against the accused. If the media is overzealous, some rascal kind of an accused, if I may say, or dishonest accused, I go to them and say, look, without telling them, I am an unknown caller. The murder weapon is lying at such and such place. The murdered bloodstained clothes are lying at such and such a place. Please, you go, you're a good channel, investigate and show the public. So they will say, look, we have found breaking news. The bloodstained weapon is lying here and this is lying here. So if that is an important chain in a circumstantial evidence case against the accused in the form of a recovery, it's lost the ground because of overzealousness and unnecessary interference by the media. In a very famous case, which I don't want to name because I'm going to avoid any channels or names, after a particular person was acquitted, the media came out with a story that the lost witness is found by us and we want to now necessarily see that he is put up before the court and he says this and he's saying that and this man is wrongly acquitted. As I said, the biggest prejudices are found today in today's day and age with bails and anticipatory bails, where people are at the threshold of their liberty, whether at a remand or at the pre-arrest stage. And this huge press coverage about the case and about what they've done and what they believe is done becomes a huge issue where ultimately People's liberties are decided more by the media than by the touchstone of law. Now, therefore, I want to point out to you very, very shortly and quickly and briskly what has happened in certain countries, because we don't have that much experience about, we have a few cases, but what I just told you and demonstrated to you has happened actually on TV channels in certain countries. In Russia, in 2009, a Russian case prior to 2009 reached the European Court of 8 honorable judges for human rights in the case of the Kuzin brothers. These Kuzin brothers were charged for suspected kidnapping. Before the trial, there was a broadcast, and the state channel, Udmurtia, in their Varsia, that is version program, decided to have a discussion. The female compere was interviewing the town prosecutor, Mr. Zintarov, the investigator, Mr. Kurbatov, and one Niktin, who was a person who was from the prosecution department. The prosecutor started his opening the program by saying the Kuzin brothers are by their, I'm saying all this because there's a reason. This is the exact example of the problem we face. The Kuzin brothers are by their nature cruel, insolent, and greedy. They wish to get cheap or free labor because they kidnapped somebody according to the prosecution case. The victim V is mild and gentle, and a person are adored. During V's enslavement, and they bring Mr. V on the TV now, he speaks in a buffered state with his face being covered. They go and portray the passport side photographs of the applicant, one of the applicants before the appearance before the European Tribunal, the Human Rights Tribunal. And his photograph was presented, and it was said that these are people we know from childhood. They are criminals from their stage. They were minors. We couldn't get them because they were minors. Now that they've reached the majority, they deserve to be convicted with the most severe punishment. These are their personal traits of these Kuzin brothers, and the others offered comments inter alia to the effect. There's a minimum punishment of 5 to 7 years. They can't escape without it. The prosecutor said, I'm going to press for anywhere between 5 to 7 or 10 years, and this is how it's going to work. And ultimately, there was also a newspaper publication on similar lines like this TV channel criticizing them. When the matter reached the 8-judge bench of the European Court of Human Rights, this was tested on the touchstone of the presumption of innocence. The doctrines that I read out earlier and pointed out earlier with respect to the presumption of innocence, the right to silence, and private rights. And ultimately, their lordships took a view that stating that a person has committed a crime, stating that the person was a criminal, rather than describing as a suspect or an accused, was a gross violation of the rights of the individual concerned. And it was a breach of Article 6 and 8. The town prosecutor had referred to the criminal record and the past record and portrayed them as hardened criminals, claiming that they had committed a crime with cruelty and meaningless brutality, which was again considered an opinion prior to trial that would affect the fair trial and affect their rights. The court found there was a breach of presumption of innocence and also found that there was a violation of privacy. Now it's interesting because in Russia, we have Article 139 of the Russian Criminal Procedure Code. Under Article 139, the press can give lawful access to the press can be given lawful access by the police to the case file, provided there is a legitimate case made out for a lawful basis for granting it. Here, one of the accused photographs was taken while he was in custody and given to on that TV program and shown in the press later. This was considered a violation of the rights, even though Article 139 allowed this in their criminal procedure code. And ultimately, the court took a view that the court declared that there was a breach of the presumption of innocence and scant respect for the right to private life and interference there. This was in Russia. In 1996, we had the US Summer Olympics in Atlanta. A security guard called Richard Jewell found a very suspicious looking haversack. It was a backpack. It ultimately turned out to be a bomb, but before that, he notified the police. The stadium was evacuated, and all all efforts were made to defuse it. Had he not done so, numerous thousands of people would have died, or at least hundreds. But unfortunately, one person died and several hundreds were injured, without even there being a case where he was tried. At the investigation stage, he was subjected to trial by the media, in as much as various journals portrayed him as being a person who was having a person of interest in the bombing. He was labeled as a person of interest. On the Jay Leno show, he was referred to as an Una Doof. Ultimately, he was vindicated. But because his case was directly contrary to the 6th Amendment to the US Constitution, which was fair and impartial jury, the US public became conscious about what was happening. And research began to flow in the United States about this. News items and research done showed that whenever a crime was committed, stories in the news about the crimes were typically skewed up and made one-sided, with an assumption that the defendant is guilty. There they have defendant, not accused. To make matters worse, what was done is that the person's past history, which is never relevant in our country also, under sections 53 and 54 of the Indian Evidence Act, the prior convictions or guilt of the accused in any case or involvement is irrelevant in a criminal trial, unless the accused leaves evidence about the same, and he leads evidence of good conduct, then necessarily it can be used. So then it's barred here also. You talk about what happened to the Cousin brothers, or you talk about a person as having a past. It's not going to be admitted in courts, but you succeed in bringing in inadmissible evidence through the press, which perpetrates into the mind of any right-thinking persons and affects it. Inflammatory statements about the case are made in cases of arrest in the US, was pointed out in most articles, and they spice up things. So there was a study done by Shirin Bakshe and Craig Harney called Psychology of Public Policy and Law in the University of California in Santa Cruz in California. This was a study which spanned over almost 26 years. And in this study, 1,381 news articles were looked into. And the statistics showed that more than 75% of cases where crimes were involved had negative publicity. It was a case where the person was called a gunning psychopath, a walking time bomb, or frightening, deadly record, feared by his own family. This had an impact on their subsequent trials, and they referred to past criminal history, confessions, which are not permissible in courts like in India. In Ireland, there was a classic write-up in the Blanket Journal of Protest and Dissent in November 2000. Bernadette and Michelle McKevitt were supposed to be involved in the bombings, which they weren't. But the media created such a situation. They were not even summoned by the police or questioned. But the media created such a situation that it was impossible to countenance the possibility that they were innocent, notwithstanding they're not even questioned by the police. They are demonized by the press. And if the media repeatedly accuses persons of crimes without producing evidence, they create a certainty of guilt in the minds of the public. And even if persons are eventually tried or charged, they have no hope of obtaining a fair trial, is what Irish analysts analyzed. When such trials collapse, the victims of the crime are left without redress. Equally, persons may be acquitted because they have lost their good name. Even if they are acquitted, they lose their name. In India, we have a case from the Delhi High Court, which aptly quotes the observations of a famous journalist called Andrew Belsey in Journalism and Ethics, published by Media Ethics. His lordship, quoting Andrew Belsey, said, "Journalism and ethics stand apart. While journalists are distinctive facilitators for the democratic process to function without hindrance, the media has to follow the virtues of accuracy, honesty, objectivity, fairness, balanced reporting, respect of autonomy. These are all parts of the democratic process. But the practical considerations, namely the pursuit of a successful career of media persons, the promotions to be obtained, compulsions of meeting deadlines and satisfying media managers, meeting their own targets of growth are recognized as factors for temptation to print stories salaciously presented. The temptation to sell stories is presented by the motive of what the public is interested in rather than what is in public interest. This was in Mother Dairy Farms versus Z Telefilms on 2005 January. The Law Commission took suo motu cognizance of this problem in its 200th law report. That was in 2005-2006. They basically said what I said earlier in the earlier part of my discussion as to what was the problem. They said the suspects and the accused, even victims, are sufferers from excessive publicity and invasion of their private rights. The police are presented in a very poor light by the media. In a day after the crime, the media say that the police have no clue. The Law Commission is saying this. Then there is gossip in the media that the line of investigation by the official agencies is not proper. And the accused is told about how the police is going to investigate so he can go to safer places and hide himself. Look at the impact. The pressure on the police builds up day to day once the case is registered and the media get into the picture. Sometimes under the pressure of the media, the police come forward with a story that they have nabbed the suspect and he has confessed. It's breaking news. As a result of the same, even if a confession is not admissible in law, it is told to the police, told to the public. This has an impact on the public mind. If by chance a police suspect in getting a confession to justify their stance before the media and to say something because there is so much negative media coverage to defend themselves, they sometimes speak about the confession. This creates a catch-22 situation for any accused. If he retracts the confession, he is shown very poor in public image. If he doesn't, even if the confession is by means which are foul, like threat, inducement, or promise, necessarily he faces the trial with an unfair procedure only because all this had to come out in the open to justify the stance of the police. The media create problems for witnesses. Witnesses' identity is not protected and there is danger from being turned hostile by accused persons. Witnesses want to retract their statement and then witness protection becomes necessarily an important casualty. If the suspect's pictures are shown in the media, the Law Commission notes this. There can be problems with identification parades. They say under the Criminal Procedure Code, actually it's under the Evidence Act Section 9, but nevertheless. Media conduct parallel trials. Judicial notice is being taken by the Law Commission. They point fingers at persons who may be innocent. They find fault with the investigation. They raise suspicion in the minds of the public and about the efficiency of the official investigating machinery. Print and electronic media face fierce competition amongst one another. So multitude cameras flash when accused are produced in the courts. Police are not even allowed to take the suspects freely and transport them by their vehicles. The Press Council of India has issued guidelines from time to time, but there is hardly any weight in them. Even if apologies are directed to be published, they are published in such a manner by media houses that they are hardly having any prominent significance or importance, nor are they published in prominent places. So this is the practical problem and this is the theoretical problem. Now, what is the legal position? Because our courts say this is wrong and our courts say there is a responsibility of the media. But where is the problem in our law that this is still happening is what I'll point out shortly. The legal position was succinctly discussed by the Lordships of the Supreme Court in 1987 SCC 386, the state of Maharashtra versus Rajendra Gandhi. The Supreme Court pointed out how that there is a procedure established by law to conduct a trial by a person who is accused of an offense. A trial by press, electronic media, or public agitation is the very antithesis of the rule of law. It can lead to a miscarriage of justice. A judge has to guard himself against any pressure and he's to be guided strictly by the rules of law. If he finds a person guilty of an offense, then he has to address himself to the question of sentence awarded to him in accordance with the provisions of law. By imposing sentence and fine and directing payment of whole or certain portion, the court has to go into the question of damage caused to the victim. The matter of fact, the crime is only against the victim and not against him only, but the whole society. Since late there have been spurt of crimes, it doesn't justify media publicity. Rajgopal versus State of Tamil Nadu was a case dealing with high-profile corrupt servants. In one breath, in 95 Supreme Court 264, the Supreme Court said there's a need to try these persons with immediate alacrity. The Supreme Court said that if excessive publicity in the media about a suspect or an accused prejudices fair trial or results in characterizing him as a person who has committed an offence, it tantamounts to undue interference in the administration of justice, calling for proceedings of contempt against the media. These are pending proceedings. I'm again going on repeating. Other issues of privacy of the rights of individuals may also arise. Public figures with slender rights against defamation are more in danger and vulnerable at the hands of media. Ankul Chandra Pradhan is that case of public servants, public officials, 96 Supreme Court, where they say, we have observed that the court dealing with the matters of public men should be conducted expeditiously, with expedition in a trial, to reach an early conclusion, so that there is credibility in the judicial process. Unless the accused result in dilatory tactics, all trials must be over in 3 months from their commencement, which is a speedy requirement under Article 21. The Supreme Court therefore expedited all these public trials and said complete in 3 months, pursuant to the Ankul Chandra case. They said Article 21. But they struck an important note of caution. Note of caution was, a note of caution may be appropriate. No occasion should arise for an impression that the publicity attached to these matters has tended to dilute the emphasis on the essence of a fair trial and the basic principles of jurisprudence, including the presumption of innocence, unless he's found guilty at the end of the trial. This requirement has to be kept in mind during the entire trial. Any observations made by this court for the proceedings, the Supreme Court says, which has no bearing on the merits of the accusation and is not to influence the trial in any manner, has not to be looked into by the trial court so as to affect the credibility of judicial process, and the same is not undermined in any manner. So while expediting these trials, the Supreme Court said no unnecessary publicity should affect the clear stream of flowing of administration of justice. The important question is, can the media even carry out a parallel investigation? In 1961, in the famous case of Saibal versus DK Sen, the Supreme Court said that it is no doubt a mischievous practice for a newspaper to systematically conduct an independent investigation into a crime for which a man has been arrested and to publish the results of that investigation. So we have a Supreme Court judgment which says this is a mischievous practice. This is because trial by media, to investigate, very important. This is because trial by media and newspapers is one of the regular, should not be by them, but by the regular tribunals of this court, and should be prevented. The basis for this view is that the action on the part of the newspaper tends to interfere with the administration of justice, whether the investigation tends to prejudice the accused or the prosecution. Again, this was a case of a pending matter because the Supreme Court was categorical. When there is a pending case, it affects justice. Now, the next question is, does the press enjoy an unfettered right to the freedom of speech? Because I started by telling you they are the important fourth pillar of democracy and they are a right to educate the public and tell them everything and disseminate information in consonance with the theory of an open court. In 96, in Hari Singh versus Vijay Kumar, the Supreme Court said that the freedom of press is not absolute, unlimited or unfettered. It said that the press is not wholly free from reasonable constraints which would disturb an orderly society and cause anarchy. The press is not to be understood to be a free press to disregard responsibility. The element of responsibility must be present in the conscience of journalists. In organized society, the rights of the press have to be recognized with its duties and responsibilities towards society. Public order, decency, morality, and other things must be safeguarded. The protective cover of the press must not be so as to throw open wrongdoings. If a newspaper publishes what is improper mischievously or falsely, it must be punished in the court of law. This is what the Supreme Court says, and they can't ignore this judicial responsibility of theirs. The Punjab and Haryana High Court in 1958 in Rao Harinarayan versus Gumani Ram said, no notion of liberty of the press can stand in the way of the powers of the court, which are inherent powers to punish any publication calculated to interfere with the administration of justice. Now, please see again, this is inherent jurisdiction of the superior courts, the trial courts, where an accused is put up at remand or anticipatory bail under 438 is being decided, they don't have inherent powers. The judgment of Bindeshwari Singh versus Kalki Singh and Major General A.S. Guraiya, 79 Supreme Court and 86 Supreme Court will fortify this contention. Since the liberty of the press is subordinate to the proper administration of justice, freedom must be confounded with a license and abuse. Freedom of the press cannot be understood to mean that freedom to do wrong with impunity, thereby frustrate and defeat the discharge of the duties upon the performance of which freedom or the well-being of citizens will depend. And let's pause for a second. If a man has to man a machine, which is of some importance, he has to have some specialized training. If you have to become a doctor or a lawyer, you must pass a professional course. There are rules that you have to follow. Unfortunately, except for general guidelines, there are no such rigorous tests or exams that the press has to pass, which would necessarily educate them in these niceties and find points which necessarily affect the rights of accused. In 1940, a division bench of the Awadh High Court in Deputy Commissioner versus Hamid said, the special privilege of the press is a time-worn fallacy. The sooner the misconception that the press is not accountable to the law is removed, the better it will be. No editor has a right to assume the role of an investigator or try to prejudice the court against any person. Finally, the Orissa High Court in Bijoy Nanda versus Baksh, 1953 Supreme Court said, on the other hand, it would appear that the responsibilities attached to the press are greater than the responsibilities of the individual. The press has a larger audience and enjoys a circulation for larger than utterance of an individual. It is true that the free press is vital to democracy, and the freedom includes the right to criticize, even the right to criticize severely. But the freedom of the press should not degenerate into a license to attack litigants and close the doors of justice. Nor can it include any unrestricted liberty to damage the reputation of respectable persons. If a journalist does not take responsibility of certain acts or the accuracy of facts which he broadcasts, or if he tortures facts and vilifies the individual, he exceeds the limits of fair comment and becomes accountable to the law. The time of the trial, the cause should be restricted only to courts and not permitted what is tried by newspapers. These are very, very strong words. These are very, very important words in the context of cases where there has been interference in cases by the media, mostly in pending trials. They should be hauled up, they should be punished, they should face action. But let us be now dispassionate and realistic about this approach. As I started by saying, either you fall in the exception to 19.2, which is one of the 8 exceptions. And in this case, it would be contempt of court, because necessarily administration of justice is a facet of criminal contempt under section 2(1)(c). And if administration of justice is breached, necessarily it would be contempt, so you fall within 19.2. Or there should be a law laid down by the legislature that curtails the press, like we had the Hindu Marriage Act, Special Marriage Act that I pointed out earlier. This brings me to the very important part of the discussion after pointing out the pros and the cons of the press and the accused and their rights that they enjoy and what they are expected to do in theory, as the practical problem that the matter that we face today. The law of contempt in our country saw 2 acts prior to the current act of 1971. In 1926, we had the first Contempt of Courts Act. And in 1952, we had the second. In none of these acts was civil or criminal contempt defined. People necessarily, the judges, decided the law on the touchstone of common law. 2 important judgments to understand what common law said need to be noted now. King versus Mirror, 27-1 King's Bench 845 was a case where an accused was arrested on 9th January and within 24 hours brought before the court on 10th January. The investigation started, and on 13th January, an identification parade was held. The offending photographs were published on 17th January. It was held that the proceedings have started. In King versus Park, I'm telling you this because I'm going to deal with the Contempt of Courts Act and point out how, unfortunately, a mistake in history has precipitated till date, which has resulted in grave injustice being done to our citizens, and Article 21 being reduced to a dead letter. So I come back to common law because we were guided prior to 71 by common law, which made a lot of common sense. In King versus Parker, 1903 to King's Bench 423, committal proceedings were not relevant for contempt to take place. It would make no difference if a particular court is sought to be derived of its independence of power to a great end is not created, or the session has not started, as long as there was contempt. In fact, Wills J. made a very important observation that you must nip it in the bud. You can't wait till the stream has crossed. He said it is possibly very effective to poison the stream and the fountain of justice while it has begun to flow, or before it has begun to flow. It is not possible to do so when the stream has ceased. All this is being stated by me to highlight that the vilification and the publications made which are negative at the initial stage prior to the pendency of the case, when the stream of justice has not even flowed or starts to flow, should fall within the foray of contempt of court. But for reasons that I will tell you now, do not, unfortunately. So in India, the first set of laws came in 1943, and prior to that, where the consistent 39, 54, 58, 47, number of judgments, that a criminal proceeding would attract contempt if proceedings were imminent. That word imminent is important because the likelihood of it culminating in a criminal proceeding, or proceedings were likely to be imminent, then it was contempt if the offending article was done in imminent proceedings. A very important and a landmark judgment, which I consider very important today from my point of view, was a judgment of the Madhya Pradesh High Court in Padmavati Devi versus R.K. Karanja, the famous editor. There the court took a view that the filing of the first information report was sufficient, and if an offending publication was made after that, it would attract the four corners of contempt. Now the interesting discussion on our country's history starts. In 1963, there was a committee called the Sanyal Committee. The Sanyal Committee was constituted to decide the laws of contempt for a new Contempt of Law Act. In 1963, the Sanyal Committee noted that though our country is very vast, the publications do not reach from one place to the other and are restricted locally, but recommended, as far as criminal matters go, the date of arrest, not FIR, but the date of arrest would be crucial. So if there is a person who is arrested, necessarily it would be a case where contempt could be allowed to be operated, the act would operate, because the test was arrest and imminent proceedings was given importance. By the word imminent was used by the said Sanyal Committee. This committee was formed in 1963, but for 6 years, nothing happened. A joint committee called the Bhargava Committee was formed in 1969 and 1970 to review the Sanyal Committee's observations on imminent proceedings. They decided to drop the word imminent proceedings for two reasons. They said the word imminent is vague, and secondly, this vague expression may unduly restrict the freedom of speech if the law applied to imminent criminal proceedings. Therefore, imminent proceedings and the date of arrest was dropped by the Sanyal Committee, by the Bhargava Committee. And in the Contempt of Courts Act, these two proceedings was not considered to be, these two tests were not considered to be relevant. Now, as I'll point out shortly, the Contempt of Courts Act speaks of administration of justice, but betrays us, if I may use harsh words, when it comes to applicability of the Act. And this is because of the Bhargava Committee's report. It did not want to adopt the test of imminent proceedings or arrest. Now, why this is important, I don't want to criticize the lawmakers, but I want to say we can't allow a mistake in history to go on using the word mistake for a valid reason. The report of the Bhargava Committee was given on 23rd February 1970. Time elapsed and the Contempt of Courts Act was enacted only in 1971. Prior to the report, maybe after it was ready, but prior to it being submitted, On 15th September 1969, the Supreme Court decided a case of A.K. Gopalan versus Nuruddin, 69 to SCC 734. The Supreme Court was considering a case of two persons. One who committed contempt before the arrest, and second who committed the contempt after the arrest. The Supreme Court in their judgment in 1969 laid down the law of this country that the date of arrest is the starting point of treating a criminal proceeding as pending. The Supreme Court had balanced the rights of suspect and accused on the one hand and the media on the other. The editor in that case had made a defamatory publication after the FIR but before the arrest, and he was convicted. Gopalan made the statement before the arrest and he was exonerated. This judgment of the Supreme Court ought to have been followed by the Bhargava Committee. It was not shown to them. Had they been a court of law, they would suffer from the doctrine of stare decisis or per incurium. But what is important to note that the other factor, namely that they found this definition to be vague, was subsequently found to be incorrect by virtue of other enactments and decisions and statutory enactments by other countries. The UK Contempt of Courts Act in 1981 and a bill prepared by New South Wales Law Commission treats arrest as the date for carrying out. Sorry, I'll continue. Treats arrest, I'll repeat. The UK Contempt of Courts Act and the New South Wales of 2003
Hello.
Yes, sir. We are waiting for you.
Oh, yeah.
Sorry, Archit, should I continue?
Yes, sir. But your video is off.
Archit, should I continue? Yeah.
Yes, go ahead.
The UK, I was pointing out. It's just impossible.
So we can't see you. Sorry, everyone. I think Mr. Ponda, we've lost his connection. Just hold on for 2 minutes. I'm sure he'll try to log in 2 minutes. I just had a word with Mr. Ponda. He's just trying to log in. So everyone just hold on for 2 minutes. Yes, I think, sir, you're back on.
Continue.
Just give me a second, sir. Yes, please go ahead, sir.
Sorry, there was some interruption about some technical problems. I was trying to point out that the Bhargava committee was flawed in not following A.K. Gopalan's case, which was decided in 1969 when they gave their report in 1970. And the law of arrest, the date of arrest was considered relevant by the Supreme Court for the purposes of contempt. But the argument of the Bhargava committee that the earlier committee was flawed in their assessment that imminence was right and it was vague was belied by subsequent judgments and statutes of various countries. In UK, we have the Contempt of Courts Act 1981, where the date of arrest is the date which is relevant. In New South Wales, there's a bill of 2003 which treats the same date as relevant. In fact, there is a famous judgment in Scotland called Hall versus Associated Newspapers. They deal with the 24-hour rule. According to this rule, akin to Article 22(2) of our Constitution, if a person is arrested, he is necessarily produced within 24 hours, and therefore he becomes a person who's within the foray and within the domain of a court. So necessarily it is
So can you hear me? We've lost you again. Hold on, everyone. Again, he will be logging in just about 2 minutes. We can't hear you, sir. Can you unmute yourself? Can you say something, sir? No, we can't hear you. Your video is without any volume. No. No, sir. I think maybe log out and log in again, sir. So maybe there is on the bottom right-hand side, bottom left-hand side, there is join audio. So try to see that you've put join audio on.
Unmuted now.
The rest, I would request if you all can be on mute still. I think sir's having some technical problems. So just 2 minutes. Can you hear us, sir? Sir, can you hear us? So can you hear us?
Yeah, I can hear you. Can you hear me?
Yes, we can. Lovely.
We just extend this a little, Archit, the meeting if required.
Sure.
Yeah, because it's very interesting, I feel, at least. I don't know.
Yes, sir. Yes, sir.
Yeah. So sorry about all these technical problems. This is all part of the COVID difficulty that I can't speak openly in public. But anyway, coming back to what I was saying, I pointed out that there was an earlier committee in 1963, which basically tried to define the date to decide when contempt can be attributed to a particular proceedings as necessarily the date of arrest. And it said if the proceedings are imminent, then necessarily you should link it back to the date and define contempt to mean date of arrest. The Bargawa Committee in 1970, 69-70, it was constituted in 69, started working on this, but ignored a judgment of the Supreme Court. Probably was not brought to their notice in 1969 in Gopalan versus Nuruddin, where the Supreme Court was called upon to decide an important issue with respect to the date. Gopalan had committed alleged contempt after the FIR but before the arrest, while his editor had done so before the Gopalan had done it before the arrest and his editor had done it after the arrest. The editor was held guilty and the date of arrest was decided as the hallmark for deciding what is the date for holding a person guilty for contempt. Now, what's important is there were two reasons given by them. One, that this was vague, and the second was it would create problems in Article 21 and Article 19 in freedom of speech and expression. These reasons are flawed for the simple reason that firstly, they didn't consider the case of Gopalan. That is a mistake in history that they've made, and that mistake continues today. Secondly, the foreign jurisdictions like England have a UK Contempt of Courts Act 1981, which fixes the date of arrest as the relevant date. The New South Wales Law Commission of 2003 bill fixes the same date. Judgments of Australia, New Zealand, Scotland, Ireland fix the date of arrest as the date and imminence as being the relevant date. And in fact, a famous case is Hall versus Associated Newspaper, where the Scottish courts decided to fix the date of arrest based on the 24-hour rule, that when a person is arrested, he's produced in 24 hours, so he comes within the ambit of the courts and if any kind of defamatory material or material which is going to affect a person's future is broadcast by the press or otherwise, if the publication is made which is wrong, affecting his character, then it would have an impact on contempt and it would tantamount to contempt. So basically, in all these foreign countries, and one more thing, after all this was done, after the 71 Contempt of Court Act was passed, we have Maneka Gandhi's case, AIR 78, Supreme Court 597, which altered the definition under Article 21 to mean a procedure should be fair, just, reasonable, not arbitrary, not oppressive, not imaginary, not in form, but in content. So this all falls in line with, because if a person is treated badly by the press post his arrest or even prior to his arrest or before charge sheet or before a case is pending, his case is no less prejudiced before judges in a trial than somebody who is defamed after the trial starts. On the contrary, his case is worse. Therefore, now we need to come to the all-important question. Do such actions tantamount to contempt of court when there is no pending case? 2(1)(c) of the Contempt of Courts Act defines criminal contempt as if it is something which affects the administration of justice, interferes or tends to interfere, or obstructs or tends to obstruct the administration of justice. If a person makes by words, spoken, written, signs, or visible representations any matter which interferes or tends to interfere or obstructs or tends to obstruct the administration of justice. Now, therefore, we're happy that no, if a man does something at the investigation stage, ultimately justice is suffered. The Supreme Court judgments I pointed out earlier said, if it affects the administration of justice, contempt. There is no problem with all this. The problem starts with section 3(1)(2) and its explanation. Section 3(1)(2) says that the Act will only apply if there is a judicial proceeding and there's a pending judicial proceeding. They define a civil pending judicial proceeding is on institution of a plaint, but the criminal proceeding is only when, in the case of criminal proceedings under the Code of Criminal Procedure or any other law, it is a date when the charge sheet or the challan is filed, or where the court issues a summons or the warrant, and in any other case where cognizance is taken post-charge sheet. So the problem is the Contempt of Courts Act does not apply to a pre-charge sheet stage or a case where you have these kind of negative publicity taking place prior to the issuance of a summons, warrant, or a charge sheet. The Contempt of Courts Act excludes this because of the Bhargava Committee and because the Bhargava Committee didn't fix arrest as the date, treating imminence as arrest as being unlawful and wrong and being vague, when history in the past and current history and post the Bhargava Committee shows this is a wrong approach. Unfortunately, this has not been corrected till date. Now, all the provisions 4, 7, 8, 10, 14, they speak of pending proceedings. There is yet another problem with the Contempt of Courts Act. Criminal contempt can only be filed on a motion directly by the Supreme Court or the High Court suo moto, or by the Advocate General granting consent. And if it is in the case of subordinate courts, if you follow the 24-hour rule, the subordinate court would have to make a reference, but in our case, it can't do it because there is no pending charge sheet or no cognizance or summons or warrant. But in ordinary course also, if it's post that, the subordinate courts have to make a reference in the case of criminal contempt. This is again another problem with the Act. So the point I'm trying to make is this is a difficult and a cumbersome procedure. And if acts take place, like I pointed out earlier about parallel investigation, this is the accused, this is the photograph, this man should be damned, like those 3 brothers in the Russian case, then necessarily if such things happen, what is the impact on the mind of judges? This was amply discussed in 1988 4 SEC 592 in the Reliance Petroleum case. They quoted Viscount Bilbon, who said, it is sometimes asserted that the judge is not affected by these kind of publications and he will not be influenced because he's a man of stern qualities and a man who's trained. It is asserted that no judge will be influenced in his judgment by anything said by the media, and there is a need to prevent publication of matter in the hearing of a case exists only when there is a jury or decided by laymen. This claim to judicial superiority over human frailty is one I find difficulty in accepting. Every holder of a judicial office does his utmost not to let his mind be affected by what he has seen or heard or read outside the court, and he will not knowingly let himself be influenced in any way by the media or in view which any layman experiences the discharge of the judicial functions. Nevertheless, I should think it be recognized that a man may not be able to put what he has seen, heard, or read entirely out of his mind, and it may subconsciously affect him. Lord Denning, MR, said the stream of justice must be kept clean and pure. It is the law, and it remains the law until it is changed by the Parliament, that the publication of a matter likely to prejudice the hearing of a case before the court will constitute contempt of court, punishable with fine, imprisonment. This, of course, again applies to England, not here, by virtue of our Act. Lord Reed is quoted saying, I think that anything in the nature of prejudgment of a case or specific issues are objectionable, not because of the side effects or because of its side effects may be far-reaching. Responsible mass media will do their best to be fair, but they will be ill-informed to slapdash or prejudice the minds of the public. If persons are led to think that it's easy to find the truth and disrespect the same and the process of law, and mass media allowed to take the judge, unpopular people and unpopular causes will be felt. Most cases of prejudicing fall within the existing authorities of contempt. Again, in Britain, I do not think the freedom of the press will suffer, and I think that the law should be clearer, easy to apply in practice. If it is made a general rule, it is not permissible to prejudge issues. Now, these are again very strong statements made by the judges, our courts, that firstly, this influence us. Secondly, we are also human beings. Thirdly, there is no difference between a judge and a jury. Fourthly, even judges are influenced. Fifthly, it doesn't go out of our mind. And lastly, and most importantly, it's contempt if it's pending. It's contempt if it's not pending in England and other countries. But in our country, if it's not pending, it's not contempt. So this is the problem. Now, in the light of this, what should we do? Should we keep quiet and speak up as we tried to do in the Sahara case and nothing happened? Instead, we leave this issue open and wait for somebody to decide it? I personally am only a common man of this country, but I believe that the folly of the intellectual consists in him not speaking up loud and clear for the values that he, by his vision and the nature of his personality, hold as sacred. Now, in the light of this, I want to see whether my approach is sanctioned by law or not. Whenever a practice operates unfairly, it is unjust. It is unjust and unfair. The Cambridge Law Dictionary defines justice as fairness in the way people are dealt with. If there is fairness, then there is justice. If there is no fairness, then a common citizen can question the absence of justice. And I'm reminded of the very strong comments made by Lord Atkins sitting in the division bench in the Privy Council in Andre Paul Terence Umbard versus the Attorney General of Trinidad, 3638 Bombay Law Reporter 681, that justice is not a cloistered virtue. I'm not talking of judges. I'm saying justice done today to people because of the lack of laws. She must be allowed to suffer the scrutiny and the respectful, even though the outspoken comments of the ordinary man. Recently, in 2018, September, Justice D.Y. Chandrachud, sitting in the bench in Navtej Johar's case, pointed out how changing society needed dynamic approach and not an approach which was stupefying and static. The Supreme Court and other constitutional courts have time and again realized that society is undergoing fast social and economic changes. Static judicial interpretation of the Constitution will stultify the spirit of the Constitution. Constitutional courts are transformative documents and necessarily fulfill an obligation, irrespective of sex, choice, and orientations. What's important to note, whether we are following the right path or not, is the judgment of Justice Bhagwati, one of the last I'll cite now, which is the hallmark of what the Bhagavad Gita said, and pointed out how change is important and how judges and the lawmakers particularly must necessarily adapt to the changes. If you are trampling upon the fundamental rights of accused, don't allow this to go on. Change. This was the case of 83-1 SCC 242846, National Textile Workers Union. We cannot allow the dead letter of the past to stifle the growth of living present. Law cannot stand still. It must change with changing. societal concepts and values. If the bark that protects the tree fails to grow and expand along with the tree, it will either choke the tree, or if it is a living tree, it will shed that bark and grow a new living bark for itself. Similarly, if the law fails to respond to the needs of changing society, then either it will stifle the growth of society and choke its progress, or if the society is vigorous enough, it will cast away the law which stands in the way of its growth. Law must therefore constantly be on the move, adapting itself to fast-changing society and not lag behind. It is wrong to consider that the concept of supervening spirit of justice, pure evil, is unknown to Indian history. Lord Krishna, in chapter 4, text 8 of the Bhagavad Gita said, Yada yada hi dharmasya glanir bharti bharata abhyuthana dharmasya tadatmanam srijamyamham paritranaya sadhunam vinashaya chadushkritikam dharma samsthapanarthaya sambhavami yuge yuge. The meaning of this profound statement, viewed after 1,000 generations to the point of courts and justice, is each day and each generation brings with it challenges and tribulations of all times. The supreme justice manifests in different eras, in different continents, and different social situations, different values. There always exists a protection, preservation of cherished rights and ideals. The reflection of the divine, broody spirit of the law, the collective conscious, intelligence for the future day, has found mention in Articles 14 and 21. The spirit that finds enshrined in these articles manifests and reincarnates itself to protect the needy in society in various ages. Values of liberty, equality, fraternity, dignity are constitutional principles. It grows stronger with covers within its sweep that great needs of time, and the spirit can neither remain dormant, static, and always fossilize. These strong words have given me the courage to speak out. I want to speak about this problem and point out that today we may be handicapped because of the absence of administration of justice being a contingency in clause 8, one of the clauses in 19.2, and the absence of there being any positive law in our country because contempt does not cover these cases. But we need to speak out and find out what should be done. There were long periods in Indian history where there were few laws, yet people practically dealt with the law, namely, they were obedient to the unenforceable. This was because they had good morals and a sense of discipline. Unfortunately, today in the age of Kali Yuga, these have eroded and necessarily corroded. The press is called the fourth pillar of democracy. A democracy without discipline has no future. I really wish that we had the discipline of the past today. Not just the press, but all of us. But my wish is akin to hydrating a dehydrated nation with an ink dropper. Having said that, I feel that the Press Council of India Act and the Prasar Bharati Act are hardly deterrents because they only deal with censure and they deal with some kind of remedial measures which are not deterrents. I therefore now come to the solutions, and I feel changes need to be made on 3 platforms. First is the preventive platform. Secondly, the punitive or the punishment platform. And lastly, the procedural platform. On the preventive platform, I say that there is an urgent need for a comprehensive legislation by the Parliament in framing a law. What law I will come to in a short time. But in case the Parliament doesn't frame the law, which they are known not to do for many, many years, and time is lost, the Supreme Court of India should, under Article 141, frame a law or guidelines to protect this most cherished and valued fundamental right. I say this because it is not the members of the Parliament who are dressed in their brief authority who are supreme, but it is the Constitution of India which is supreme, and Article 21 is part of this Constitution. The urgent need of the hour is that the third pillar of strength is the Supreme Court of India, which may be required to consider laying down a law on the touchstone of Article 141 of the Constitution of India. This may be done by passing necessary directions not to allow any publication that relates to or is connected with the details of investigation, which impede the progress, process, or affects the rights of an impeding investigation or subsequently ultimately the administration of justice. Now, for this, we can take a clue from Section 8(1)H of the Right to Information Act 2005. This whole argument of the public being required to know and the press therefore reaching out to them and doing all sorts of things directly or indirectly, the right that the public have to know is aptly answered by one Section 8(1)H, which says basically that the public has no right to information that would impede the process of investigation or apprehension or prosecution of offenders. Now, as a logical sequel to this, that which cannot be done directly cannot be done indirectly. By claiming that the press are merely providing information to the public in the guise of freedom of speech, they cannot trample upon the fundamental rights of accused even at the stage of investigation. A law is required in this regard, which is a more potent tool where prevention will take place and breach will ensue serious consequences. On the punishing platform, I sincerely hope and pray that the framers of the Constitution, namely the legislature today, who are going to have powers under 368 to amend it, would include a 9th category like was done in Romesh Thappar's case after the 1950 judgment that public order is not part of Article 19(2), to include administration of justice as a clause in the 9th exception, as one of the exceptions, namely the 9th one there. The reason is that public order was added, administration of justice is as important as contempt of court because it forms part of the definition of contempt of court. But I know that amending the Constitution is a cumbersome procedure. Under Article 368, you require a special majority of 2/3. Then I say at least, and I'm saying the word at least again, you should relate it back by amending the Contempt of Courts Act to the date of arrest. We need to amend Section 3 to include the date of arrest as being the starting point. We cannot allow a mistake of history to repeat itself and be allowed to multiply. One cannot forget that the Bhargava Commission ignored the Supreme Court judgment or it was not brought to their notice. The date of arrest is neither vague nor contrary to the procedure of Articles 19 and 21. Maneka Gandhi's case came after that, which supports my contention in India. The law in Scotland of the Hall case of the 24-hour rule supports my contention. Similarly, the UK Act of 1981 and the 2003 Commission of South Wales and other judgments of UK and other countries necessarily, like Australia, New Zealand, support this view. Therefore, I feel that this should be amended. Now, why did I use the word at least? And why did I use the word at least for arrest? I believe personally that the 63 judgment of the Madhya Pradesh High Court in the case of Karanjia, where he was a respondent, that the date should be the date of the FIR is of greater practical importance and will have a greater bearing. I say this with greatest respect because of the changing times from Gopalan's case. Imagine a case where at the stage of anticipatory bail, a person is not arrested, so he goes to the court to protect himself. Is this case different from a man who's tarnished after the arrest? Can it be said, please don't forget, Gopalan was discarded in 1969. The committee report of 63 was in 63. There was no provision for anticipatory bail in the Criminal Procedure Code. The matter was not tested to the touchstone of anticipatory bail and with the changing times, and that's why I had to go to Yada Yada Dharmasya. Law has to change and adapt to the fact we cannot go into blinders. Yesterday, Justice Deepak Gupta, while retiring from the Supreme Court after a 42 years long stint, said, the judges in the Supreme Court cannot be ostriches, where we simply ignore things and forget them. So they're very important. You can't just ignore the fact that this happens in anticipatory bails day in and day after. And I'm fortified with these submissions based on 2005 to SCC 686. MP Lohia's case. There, a woman committed suicide. And she was not in her husband's house, but in a matrimonial home. The accused moved for anticipatory bail in the High Court of Calcutta. There was an article published at that time, Saga, doomed by dowry. The matter came to the Supreme Court of India, and while the SLP was pending, there was another article of similar lines, not pointing out anything in favor of the accused and trying to doom them. The Supreme Court was disturbed by this and lamented that the facts narrated and the materials may be used in the forthcoming trial, we have no hesitation that these kind of articles contain an interference in the administration of justice. We deprecate the practice, caution the publisher editor who are responsible against indulging in trial by media, which is sub judice. Now, please note, I forgot to tell you, and importantly, I must tell you, the matter was like this. The death of the said Chandni took place on 28th February. An anticipatory bail was decided by the Calcutta High Court, and thereafter the SLP was filed for anticipatory bail in the Supreme Court. In the light of this pendency, the Supreme Court said this about the matter. Having regard to the present case and regard to the fact that the matter is closed, we hope that the media will act responsibly and editor, however they granted anticipatory bail. Now, therefore, 3 points on this. It should not relate only to the date of arrest, at least the date of arrest, but it should go back to the FIR because one, there was no ABA, and ABAs at that time were not existing. So the problems that take place after arrest in bails should be also equated with the problems that take place at the stage of ABA under 430. This is my first submission. Secondly, when the Sanyal Committee passed the report, they banked heavily on the fact that arrest should be used as the date because, according to them, there was no publicity all over the country for newspapers, and necessarily it was only local. Now the times have changed and one cannot ignore what has happened. The damage is far greater today. So this calls for a change on the platform of the Contempt of Courts Act with respect to definition. Another important change that I would sincerely request from the legislature is that the cumbersome procedure under 15, if it's brought under contempt of court, should be changed. You don't need to go to the Advocate General or make a reference. Parties who are affected should directly be able to go based on the 24-hour rule and the Hall principle, which is important because if an accused is defamed in 24 hours or if they accept date of arrest post that, the magistrate's court is the concerned court on which contempt is committed, and they should move the High Court because only the High Court can punish for criminal contempt. The last submission, live streaming. Going online and broadcasting court proceedings by means of internet, obviously post-COVID, because right now I don't see the proceedings being broadcast, but post-COVID, when we do recover at some stage, the burden of the press to keep the public informed would necessarily be lightened by this. The public will know they can log on to any channel, and particularly I'm saying this in the light of trial courts, where they can easily go and see what is happening and see, so that unnecessarily there are no usage of words, usage of unnecessary adjectives like caustic language, so that it affects the person's rights. Live streaming is in consonance with the concept of an open trial, and I feel it's a positive and important step where the trial courts, at least constitutional courts, the matter is being decided. Finally, I hope and pray that if these suggestions are enacted, it will have a salutary check on any tendency to ride roughshod on the fundamental rights of an accused. And I also hope that this will insulate against any insatiable appetite to encroach upon the fundamental rights. A big thank you to everyone.
Thank you very much, sir. That was really, really informative. A couple of questions that have come, and if you don't mind me asking.
Of course.
The first question is from Ashish Jha. He asks, police personnel in Palghar lynching have been condemned by media for their inaction. Can this be seen as a media trial, even in the presence of videos showing their inaction?
Look, first of all, I won't want to comment on any particular case. I started by saying this. I would prefer to refrain from answering this question on the ground of it being a Palghar case or the persons involved are known to me or otherwise. And in fact, there would be some professional conflict. But I can only say one thing on a general example. I've been very clear in what I said today. Keep aside any particular case. If a particular matter at this juncture attracts a case which is prior to charge sheet, unless it falls in the exception to 19.2, or it takes place in a pending proceeding in a superior court where they have inherent jurisdiction to pass such orders, the question of committing contempt would be one which is questionable.
Thank you, sir. Second question that I will read out is from an anonymous person. It says, sir, nowadays the media interference has increased, as it can be seen in the Mumbai attack at the Taj Hotel or even in the Peter Mukherjee case. It was more in it was more in media during the investigation. Do we need guidelines not to repeat such incidents in the future?
I have said this, I've answered this today. I've spoken about the solutions. I've said you need a law. You just don't need guidelines. You need a law. You need to amend the Contempt of Courts Act to bring arrest within the foray. But that is not preventive. That is punishing a person. The difference in civil and criminal law here I'll highlight. In civil laws, you can stop an action with an injunction. That is the first thing I said today. The procedural is the last. The first is to prevent it. How do you prevent it? You prevent it by laying down a law that if you do this, you're liable. Things like contempt are all punishing. They all say that after you've done this, you're liable for these consequences because they've done so. So I think you can have a law on this, and you can alternatively amend the Contempt of Courts Act to bring in pre-charge sheet, including post-FIR or post-arrest proceedings.
Thank you, sir. Just to follow up on what you have just mentioned, my personal question would be that to what extent then would you balance out this law, assuming that a law was enacted, as to the media's responsibility to report these kind of matters? Because at some point, sir, the public needs to know, and also the media's responsibility not to cross a line, not to overstep their limits. And I mean, where do you stop? What would you think would be the place to stop?
So basically, I think the media, as lawyers, this is very easy to answer, but you have to step into the shoes of the media. I think the media should be educated to understand what is an investigation in a criminal case. It's a very sensitive act. It's an act that needs some time. If a crime is committed, you must leave it to a specialized agency who's trained in law to deal with it. If the agency is not performing its part and the agency is keeping a blind eye, you can point out the inaction and you can say, no FIR registered despite the fact that there is a gruesome offense committed. But you have no right to overstep the line and investigate into that offense. You have no right to attribute motives to the investigating or to people. You should necessarily restrict yourself to what is apparent and not what you presume. Because all this is inadmissible evidence can never be brought on. By inadmissible, I mean your parallel investigation. You have no power under 161 to record a statement. By inadmissible, I mean you go into confessions of accused. The law prohibits it. By inadmissible, I mean going into past history. It's not permissible to go into this in a court of law. This can't be used as the basis to convict a person or in against him. By inadmissible, I mean necessarily you follow rules and regulations under the statute, which you are empowered to do. Where is the power with the media to do all this? As watchdogs, you can open your mouth. There are many cases the media has come to the rescue when there's inaction. I'm aware of that. But necessarily it is something which is they have to learn to draw the line. Once an investigation is being carried out, according to me, they should lay their hands out. If the verdict from the court takes place, you have every right to comment on it. But at the investigation stage, you should be more loath and circumspect.
Thank you, sir. Sorry, I'll follow up again with another question. We are recently seeing the arrest of a famous or a prominent figure who is the MD of a bank. Of course, the size of the offense or the amount that is involved is sizable. And sometimes we notice on a practical situation that as soon as the amount is mentioned, there is an hesitation or there is immediately an inclination to think that this person has done something wrong because the amount is big. Now, when it comes to the media's role in this, the media is only reporting what they perhaps are told or become aware of from the investigation, and they are reporting this. But as soon as they report this, there is an immediate kind of counter effect that you see the next day if you're trying to argue a matter in court or you're trying to argue an application in court. So would you still hold that the media is responsible or is irresponsible in their reporting because of this?
First of all, I take great offense to the investigating officer sharing details of the investigation with the media. They have no business to do so. Investigation under the Criminal Procedure Code is exclusively the realm of the police and the police alone. Even superior courts don't interfere. There are at least 12 cases. Divine Retreat in 2008 reproduces this, deciding all the cases right from 45 Privy Council, page 18, which is the case of the famous case of Nazir Ahmed. It is a realm of the police and the police alone. Nobody interferes, not even superior courts. Why should the media be educated about the niceties of an investigation? At best, they can say XY is arrested. Allegations are that he's involved in a fraud of so-and-so, remanded to custody for so-and-so day. That he transferred this money, that he did this, that this is reported, that that is reported. Today, the media is aware what's going to happen tomorrow if the judges don't know. The investigating officers recorded the statement of this. Why should the media know all this? What right do they have to know on this? Under what provision of law can the IO give out this information? That is why you have 81H. There is a very, very important figure. The general public are not entitled to know this. The media is under no obligation to disclose these facts to the public. And in their so-called curiosity to learn these facts, based upon a notion that they share that this is for the public, they are completely wrong.
Thank you, sir. Thank you. That is absolutely clear. There is a question that's come from Vaibhav Bhure, who says, sir, in your view, the proposed amendments mentioned in the draft amendment bill 2006 to the Contempt of Courts Act, suggested by the 200th Law Commission report on trial by media, which recorded the suggestions made by the Sanyal Committee and the law laid down in the Gopalan case, should have been accepted by Parliament, where the expression pending was proposed to be substituted with active in the context of criminal proceedings and in the explanation B1 to section, where offence, challan, summons is mentioned. It was qualified by the expression whichever is earlier, which did not find place in the Amendment Act of 2006. I think the question is that should this have been therefore implemented, which did not find place in the Amendment Act?
Of course, the amendment should have been implemented, because I will tell you, the Contempt of Courts Act has not been amended after that. After 1971, this you know something, this 200th Law Commission report was not a report that was asked for. It was a suo moto report, cognizance of which was taken by the Law Commission suo moto.
So may I request you to come closer to your phone a little bit? Yeah, just.
This report was suo moto. This report was suo moto, prepared by the Law Commission, realizing that there are difficulties faced by accused persons in trials and at the pre-trial stage. They wanted it to get related back to the date of arrest. The Law Commission's report has not been considered till today by the Parliament for reasons best known. Therefore, now, ultimately, I say that the Law Commission's report should be the guiding factor for future, where they have spoken much of what I have said today, including the fact that the date should be reckoned as arrest.
Thank you, sir. There is a question from Mr. Jaikar, who says that then sometimes what happens is, sir, that you are placing a premium on corruption for with regard to the police involved in the investigation, because we sometimes note that when the media breathes down the police's neck, that time it avoids corruption that takes place because there is a media spotlight. So how do you balance this out?
But this is not in a pending investigation. This is before the case has come out. So if somebody is not doing anything, I told you, inaction can be reported. Once there is something happening and you're not satisfied with the courts of law, the law courts are not shut down. If they start deciding everything and they start deciding the guilt and innocence and they decide who's corrupt and who's not, then where is the question of there being a trial or there being any decision by the courts? So necessarily, I have to only say this, that media can open their mouths, they can try to bring to the fore crimes which are not being detected and nothing is done. But that doesn't elude them to go to courts of law when they are required to. If they find that nothing is being done, they must leave something to the courts. Today, they are usurping that function.
Thank you, sir. A question from Advocate Anand Thotange. How do we stop the media if we find that they are doing so continuously for 7 or 8 days? If they just share,
So under the judgment of Sahara versus SEBI, if you have a pending proceeding, then it is permissible to apply for.
So we lost you.
Possible to apply for a postponement order, where you.
Sir, we've lost you again. Just a moment, everyone. I'll just call up Mr. Panda and ask him if he's able to join back. will be joining us in just a minute.
Okay.
Yes, sir.
Okay, go on.
The question was, how do we stop the media if we find the media doing it continuously for 7 or 8 days?
I told you there are two stages. One is if there is a pending proceeding, you can go to the superior courts like the High Court or the Supreme Court, and in our case, if it's a state matter, to the High Court, and ask for postponement orders, as Justice Kapadia said in the case of Sahara versus SEBI. These postponement orders are orders which are passed for a temporary period, prohibiting the media from publishing on a case-to-case basis, based upon the prejudice and the problems taking place. Other than that, the subordinate criminal courts have no power. You can't go to the trial courts and tell them to stop any publication unless it comes within specified exceptions like rape, etc., which I told you. So if you're actually being tarnished today, the only way to go about it is if you go to a civil court and obtain an injunction, which I doubt can be given against the police. So it's really a situation of catch-22 where an accused is behind bars. I'm talking very practically. An accused is behind bars. Is he really bothered about the media, or is he really at that stage bothered about his safety, his security, his freedom, and his case that he has to face? Is he going to be able to defend himself? Is he going to file a writ petition in the High Court and say, I'm behind bars, they're tarnishing my reputation? And who's going to take that seriously today? The law is such that unfortunately today, we don't fall in those restrictions of Article 19 because of the problem with the Contempt of Courts Act. Once you say that it is only summons, warrant, or charge sheet, and then only you can necessarily say that a man is supposed to be pending before the court, his case is pending. The entire argument is one which is very serious, one which requires the call of the day is necessarily a change in the law.
Thank you, sir. We'll take the last question now. It's from Mr. Bharat Bhatia, who says, how can we stop the media, as nowadays the medias have started a trend of sending messages like to sign an e-petition for the death sentence of an accused whose trial is not even conducted. So basically, I think this whole spread that sign this e-petition and join this campaign, or how do we stop that? Is there, of course, what is your view on that? And
I think it's very simple. Now, if somebody did this on Twitter or Facebook, what could you do? Forget the media. If you or me did this on Twitter or Facebook, then how do you stop them? It's as simple as that. If somebody decides to sign a petition and you choose to join him in a particular act, you may share those views, but that's a different issue. The issue is that there in that petition, if there is something which is defamatory, they can always file. But I'm telling you, these are all, sorry to say, only remedies available on books. There's only lip service. There is no kind of actual, who is going to file a defamation case in this country against the media and wait for 10 years or 20 years for justice? Therefore, the same remedy available to a person against Twitter or Facebook would be available against media. You go and you obtain an order and injunction, because even retweets and re-forwarding could invite good action that this is what they're doing something wrong. Or you have to go to the civil court and get an injunction that you stop this man. I don't want to name him, you will all guess. A very famous personality who immediately moved to the Delhi High Court and got proceedings stayed when they was likely to be defamed in the eyes of the public. A very, very famous case that came about 7 or 8 years ago. He realized that this can lead to an investigation. He got no reporting, nothing to be done, things to be kept in sealed cover. So you have to stop the media like this. But this is not enough. Sometimes these things are not granted. And an accused who's handicapped, who's behind bars, who's illiterate, has equal rights like a literate man. A literate man may be able to go to a court and get an injunction. What about a poor man who doesn't have money to defend himself with a lawyer? Where is he going to move a high court or a city civil court for an injunction? So the point I'm trying to make is this is not effective enough. You need a law. You need an amendment. You need necessarily some kind of a change in the Contempt of Courts Act and or the Constitution and or enactment of a new law where things are defined. Somebody must sit down and take the arduous task of trying to reach the truth and trying to understand that this is not just the prerogative of the parliament, but ultimately it's a question of the Constitution and of Article 21, which is the most cherished and the dear right.
Thank you very, very much, sir. I think we have reached the end of the question answer session as well.
Thank you.
On behalf of everyone who's attended this talk of yours, on behalf of Jaikaran Partners, and on behalf of every law student or every person who's keen to follow the law, sir, today's talk was informative, it was educative, and it was something that we all have really learned a lot from. We really thank you for taking this time and giving us this.
I thank each one of you for taking time off on a Friday evening at 5 o'clock, wasting your time, if I may say, or investing your time in a very, very, I would say, interesting topic. At least it doesn't cease to fascinate me ever, this topic. So I think it was something which I enjoyed, and I hope everybody did too. Thank you again to all of you, and thank you all of you from Jaikar Partners for giving me this opportunity.
Abad, on a Friday evening in a lockdown, it is as good as a Monday evening or a Tuesday evening or any evening, if you ask me.
I think people like to go for walks, no? Just now, even then, they like to exercise. They like to do so many things. It's a routine which people follow. So I don't want to comment. Whoever has taken the trouble to come today, I remain indebted and grateful to them. And thank you for the invite again.
Thank you very much, sir. We look forward to hosting you once again in the near future.